Hi, this is Sandy with your weekly Diamond Girls update. I'm here with Mathew Greene, who's the probate judge for New London and Waterford, and he's going to talk to you about some issues that have come up in the probate court regarding real estate.
Thank you, Sandy. It's a pleasure to be here. One of the issues that comes before the court has to do with jointly held property. Usually a property is held by a husband and wife jointly, and when the first one passes away, the surviving spouse has a tendency not to come to the probate court because they feel that they've owned the property and the property is automatically theirs. Unfortunately, what happens, there's an inchoate tax lien that gets attached to the property, and that usually comes about or to be known to the family when the children go to probate the estate for their last parent to pass away. So the word of advice that I would give you here is to make sure that even though property is held jointly, that with this inchoate tax lien, that you get to the probate court and you make sure that the first of your parent to pass away, that you go and fill out the proper paperwork at the court to remove the tax lien, so when your second parent passes away, the estate is much easier to handle. You only have to deal with one estate. Another issue that comes before the court has to do with living trusts. You see these advertisements for these living trusts all the time as a way to avoid probate. Well, actually you don't avoid probate, because this inchoate tax lien that I just previously spoke about also gets attached to property that is held in trust. This tax lien is attached to property that transfers upon death. So the promotion that they give with regard to avoiding the high cost of probate or avoiding taxes is not necessarily true. Another issue that comes before the court has to do with transfer of real property. A lot of times a parent will want to transfer the property to their children as a way to avoid probate. Well, it's not as easy as it sounds. What happens is that when you have a transfer of real property, you get your parents' basis in that property. You know, many times the parents have bought the house for $40,000 30 years ago, and now it's worth $200,000 or $300,000. If you go to sell that property and you don't live there, you can get hit with a large capital gains tax. That obviously is not the intent of what your parents wanted, and it may be easier to transfer that property in a will.
Are there any gift tax ramifications if you transfer a property?
There could be gift tax ramifications. That's something you'll have to consult with your accountant on. Many people ask probate judges, is it important to have a will? They ask their attorneys the same question, and of course the answer is yes. The reason why it's important, because the will can set forth certain powers that a fiduciary or an executor can have, and one of those powers can be to sell real property. If you don't have those powers pursuant to the will, then you have to go to the probate court and get permission from the judge to sell the property. So if you are an administrator of the estate and not an executor is someone who is appointed by a will, as opposed to administrator, someone when there is not a will. If you are an administrator, you need to, and you're going to sell a piece of property, you need to have in that contract subject to probate court approval. Of course, when you come before the court, we're all ears and we try to help everybody the best we can.
That was great, Matt. Thank you so much for coming. That was great information, and we'll see you guys next week.